A very good day to you wherever you are in the world. We welcome our international audience and the members of the Bar Association here in Sri Lanka and overseas, and our viewers from all over the world to this 148th episode of the Bar Association Webinar Series 1. BASL is proud to be presenting this episode in collaboration with the Bar Council of England and Wales. Here to discuss illegal fishing and waste dumping under public international law is a panel of experts whom we warmly welcome while thanking you for the generosity of your time and expertise during this knowledge transfer session. Those of you who wish to direct your questions can forward the queries through the chat line that will be directed to the panel through the Q&A session. This is a milestone initiative brought to you by the Bar Association of Sri Lanka, particularly the seminars committee that works tirelessly behind the scenes to roll out the session. To mark the significance of this collaboration, we will, which is the first of many with the Bar Council of England and Wales, is the President of the Bar Association of Sri Lanka, Mr. Salia Piris, President's Council, who will speak a few words now. Sir, if you can join us now.
Yes. So let me welcome you all to this webinar, which is being done by the Bar Association of Sri Lanka in collaboration with the Bar Council of England and Wales. And we hope that this would be the start of further collaboration between our two associations, and that in the future that we could see in other spheres also cooperation between our members. And let me thank the expert panel, and especially let me also thank Paul Mailwaganam for bringing this two associations together in this project. Thank you.
Thank you, sir. It is now my pleasure to be introducing our esteemed panel, starting with Professor Andrew Surdey. Professor Surdey has since 2015 held a personal chair at the University of Southampton, having successively been a lecturer and a reader in public international law, and was a director of the Institute of Maritime Law within Southampton Law School from 2017 to 2020. Before his appointment in 2005, Professor Surdey was briefly a solicitor with Fernhill, Hollandale and Page in Sydney, and then worked for many years in the Australian Government Department of Foreign Affairs and Trade. There, he served in several diplomatic positions, including postings in Tokyo and Warsaw, before specializing from 1996 in the law of the sea in the department's Sea Law, Environmental Law, and Arctic Policy section. In his capacity, he appeared for Australia in 2000 in the Southern Bluefin Tuna arbitration, and later was involved in the preparation of Australia's 2004 submission to the Commission on the Limits of Continental Shelf under Article 76 of the UN Convention on the Law of the Sea, as well as with the negotiation of 2003 Sunrise Turbidor Unitization Agreement with East Timor. He was also part of the negotiation in 2004 Maritime Boundary Treaty with New Zealand. Since then, Professor Surdey has been an invited expert at workshops organized by the Food and Agriculture Association of the UN, the OECD High Seas Task Force, and the Inter-American Tropical Tuna Commission, and a member of the UK delegation to the 2010 UK-Canada Colloquium on Arctic issues, as well as co-authoring reports to two committees of the European Parliament on international fisheries and deep seabed mining issues. He most recently led the last phase of the Institute of Marine Law's contribution to the Sea Traffic Management Validation Project. Before that, he was involved in its unmanned ship project for the European Defence Agency. He is the author of The New Entrant Problem in International Fisheries, Cambridge University Press, 2016. Thank you, sir, for being on our panel today. We warmly welcome you to the session. We also have with us Ms. Penelope Neville, barrister at law. Welcome, madam. Ms. Neville is a barrister at 20 Essex Chambers in London, who specializes in international law. Her practice focuses on dispute on transactional advice across a range of areas, including public international law, EU law, public law, and human rights. Commercial disputes raising questions of international and EU law and the interaction between legal systems and regimes. She has appeared as counsel before the International Court of Justice, the European Court of Human Rights, the General Court of EU, and the United Nations Convention on the Law of the Sea, Annex 7 Tribunal on dispute between UK and Mauritius over Chagos Marine Protected Area, as well as High Court, the Court of Appeal, and the Supreme Court of England and Wales. Ms. Neville's career commenced as a litigation lawyer in New Zealand with the leading firm Chapman Tripp, and includes time as a full-time academic at the University of Cambridge, teaching public law, EU law, and the law of armed conflict. She is currently a visiting lecturer at King's College London, where she covers and lectures to LLM students on ocean governance and teaches the law of the sea to undergraduates. For the last 4 years, she has lectured in the International Tribunal for the Law of the Sea Nippon Capacity Building and Training Program. She is regularly instructed in matters concerning law of the sea. Recent work includes work on the ongoing UN negotiations on the new internationally legally binding instrument on conversion and sustainable use of biodiversity in an area beyond national jurisdiction, and the San Pedro Pio case involving transfers of San Pedro Pio in Nigeria and its subsequent arrest and detention. Thank you, Madam. Honored to have you with us. I now welcome Mr. Sailesh Mehta, barrister at law. Sailesh Mehta has practiced as a barrister for over 30 years. He sits as a recorder of the Crown Court part-time judge. He is a leader in his field in environmental law. Mr. Mehta has prosecuted and defended in some of the leading environmental cases in England and Wales. Through a series of cases in the Crown Court and the Court of Appeal, he has helped develop the law relating to international shipments of waste from Europe to developing countries. Mr. Mehta has lectured extensively in Europe, Australia, and Africa, and often as a part of a judicial delegation. Welcome, sir. And to manage the discussion on behalf of the Bar Association of Sri Lanka is Mr. Chandaka Jayasundara, President's Counsel. Mr. Jayasundara was enrolled as an attorney at law of the Supreme Court in 1991. He was appointed President's Counsel in 2017. He practices his law in civil and commercial litigation in the District Court, Commercial High Court, and the Appellate Courts. In the year 2008, he obtained an LLM in international trade law from the law faculty of the University of Colombo. He is the chairman of the legal subcommittee, an intermaritime committee established by the government with regards to response of Sri Lanka in respect of the Express Pearl incident. In 2021, he was appointed by the Cabinet of Ministers as chairman of a committee to study and report on updating the laws relating to maritime sector in Sri Lanka, and was appointed by the Ministry of Justice as chairman of the Sectoral Law Reforms Committee for Maritime Law Reforms in the justice system of Sri Lanka. Sir, over to you.
Thank you, Tanya, and good day to all of you. And I would like to commend the Bar Association and also the Bar Council of England and Wales for giving an opportunity to our audience to look at the conceptual aspects of three areas of maritime related law in Sri Lanka, which has come up during the last couple of years. So as a very brief introduction, because we are running pretty tight on time, a brief introduction, we will be looking at illegal fishing, illegal, unlicensed and unauthorized shipping, which presentation will be done by Professor Serdi. That is important, although to a certain extent the problem has dissipated for the moment. It was a very topical issue a couple of years back, around about 2015, 2016, and 2017 with regard to the incidence of illegal fishing by primarily South Indian fishing trawlers in the northern waters, specifically the Mannar Basin and also the Pork Straits. So just to give an idea about that, if I can just show how bad the incident was, or the incidents were at that time. So this, I think, was somewhere in 2015, 2016. This was a daily occurrence in the northern Mannar Basin and the Pork Strait. So you can see by 4 o'clock in the afternoon, all the boats, trawlers, mainly bottom trawlers, all gather. By 8 o'clock. Some of them are here. By 1 o'clock in the morning, the entire fleet is in Sri Lankan waters, and by 4 o'clock in the morning, they start going back. So that was the ground situation at that time, and I had the privilege to represent some fishermen's cooperative societies from the north, and made representations to the Supreme Court with regard to the violation of their fundamental rights by the lack of enforcement by the state in respect of this incident. So the government at that time was quite reactive, and was immediately took steps to amend the Fisheries Regulations Foreign Fishing Boats Act in 2018, by which the enforcement process was streamlined to bring the enforcement down to the magistrates court jurisdiction level. And more importantly, since it was a humanitarian crisis, because all the fishermen arrested had to be languishing in remand prison in Sri Lanka for a considerable period of time, system was stipulated so that the fishermen were given suspended sentences immediately, and within a couple of days they were repatriated to India. However, the boats were all confiscated with the expectation that if the owners wanted, they can come and pay the fine and take the boat back. However, very few owners have come to recover those vessels. Now we have a bigger problem that the fisheries harbors are now full of confiscated boats. Adding to that topic, Sri Lanka is also very much interested in unauthorized and unlicensed fishing, in view of the fact that the fish export of fishery products from Sri Lanka is increasing exponentially, and the regulations and the laws that dictate or that applies to such fishing in Sri Lankan waters are the European standards, European conventions, European laws, as well as the US and international conventions. So for the audience in Sri Lanka, it is very important to have a conceptual and a legal background of a problem which is quite local to us, but can be resolved by use of international conventions. Then Mr. Mehta will be speaking about dumping of waste. Again, something that was topical a couple of years ago. We will all remember, but with regard to some 40 or 50 containers that were brought in from the UK, and which was creating an environmental problem in Sri Lanka, and there were serious legal issues, and I think some litigation is still pending in the Court of Appeal. So he will be talking about the international aspects with regard to dumping of waste. And the last topic that we are dealing with will be the Express Pearl incident, which is the most recent topical issue, and how international conventions, international provisions will help in Sri Lanka arriving at or obtaining compensation for what some say is one of the biggest maritime disasters generally, and specifically with regard to plastic pellet contamination or contamination. The biggest incident where plastic pellets have created such an environmental disaster. I think the second one is from Australia. So these three topics are very, very topical. And I would just want to say, like, since most of our Sri Lankan audience will know, the Sri Lankan legal system is not the fastest legal system to adapt to new changes in international law, especially because we are a dualist system. Even if the executive ratifies the conventions, bringing those conventions into operation has to be by an enactment in Parliament. And especially with regard to technical conventions, like the hazardous and noxious fuel convention and seriously technical conventions, getting it into Parliament has become a logistical nightmare due to the fact that every single convention has to be translated to Sinhala and Tamil. So in these law reform committees that have been set up by this government about 3 months ago, especially in view of the incident with regard to the Express Pearl, one of the main areas that we are looking at is how to bring the Sri Lankan maritime sector laws up to date with international standards, international conventions, and obtain experience with regard to how other countries have brought these laws into operation and brought their countries' legal parameters up to standard. So in that regard, this is a very opportune webinar, and having such eminent speakers talking on these topical matters, topical conceptual matters and conventions will be most important, because we are more worried about the immediate impact of these incidents to us who are facing these incidents. But all these can be solved by using the legal regimes that have been established internationally. As a concluding remark, I must say that the Sri Lankan government, in respect of both the illegal fishing incident and the claim on the Express Pearl, has taken a very non-confrontational approach, and always has approached, even with regard to the illegal fishing and the Express Pearl, on a more strategy of negotiating and arriving at a solution together with whoever who's creating these problems, rather than imposing strict laws and enforcing those laws. But when laws have to be enforced, it has to be enforced, and that is why we require guidance and advice internationally as to how to take our laws, which are, some are quite up to date, but some lack modernity. How the experience of international academia and experts like the three panelists today can help Sri Lanka to update its legal system to a standard where any untoward incident like what has happened, even if it does happen, can be resolved with the best benefit to Sri Lanka and the general international laws. So I don't want to take too much time. I would like to ask Professor Serdi to start his presentation, and subsequent to that Mr. Mehta will speak, and after that Ms. Neville will speak, but I will introduce individually each one. Professor Serdi, it's over to you.
Thank you very much, Mr. Jayasundara, for the very helpful introduction that sets the scene. And I should also express my gratitude for the invitation to speak this evening. It's a great honor to have been asked to do so. Can you see my screen? I'm rather hoping that what I'm attempting to share is what you're seeing. It's my my
yes, we
opening
can.
slide.
We can, Professor.
Oh, excellent. Well,
Thank you.
what I'm going to give you this evening is in fact two more or less unrelated mini talks. One on the dispute settlement mechanism under UNCLOS, the UN Convention on the Law of the Sea, which will actually come first. I forgot to reverse the order. And then secondly, some remarks on IUU, that is illegal, unreported and unregulated fishing, and the confusion that arises very frequently between its components. So they're both rather abstract because, as Mr. Jayasundara has told us, there is no litigation really in prospect here, but it's more a taste of what might happen if at some point Sri Lanka either decided to explore the prospect of litigation or perhaps was itself sued by another country as a result of whatever action might be taken. Now, I just need to, what I'm trying to do is to move my, here we go, yes. So let me just make sure that I haven't missed anything. No, my screen is now operating as it should. So in the first half, I'm simply giving you an overview of the main features of the Part 15 system for compulsory settlement of disputes under UNCLOS, how the system works, the so-called cafeteria, which is the menu of choices that states have, some of the main machinery provisions, including the options to seek provisional measures and also the prompt release type of case. And then lastly, a couple of exceptions that might be relevant. Now, it's often said that UNCLOS, or the Law of the Sea, has a compulsory dispute settlement system. These couple of exceptions aside. So the system is there for disputes that concern the interpretation or application of the convention. Well, it's true to say that it is generally one of compulsory settlement, but I think it's important to bear in mind that ultimately international law always operates on the basis of consent, and nowhere more so than when it comes to dispute settlement. So it's rather an oversimplification to say that this is a compulsory system, because it's based on the consent expressed by states, in this case, by voluntarily becoming party to UNCLOS, as Sri Lanka has, along with 160 or so other states. So the consent lies in the fact that Sri Lanka has chosen to become party to the convention. Now, one of the ways in which international courts and tribunals can be given jurisdiction over particular disputes is via what is called a compromissory clause. So within the treaty, you will find, or within a treaty, you will find a provision towards the end that says that should a dispute about anything to do with the treaty arise, then any of the parties can simply invoke the clause and take it automatically to some method of dispute settlement that has been pre-agreed. So again, the jurisdiction of the court is provided by a mechanism that is given in advance of any dispute actually having yet arisen. We don't know what disputes may lie in the future, but when it happens, the court can be seized and proceed to deal with the dispute. So Part 15 of UNCLOS is in fact 21 articles long, so you might well take the view, as I do, that it forms a particularly complex type of compromissory clause viewed as a whole. Well, it begins with Article 279, and I'm not going to go through every single article, so don't worry about that. But Article 279 is very general in its terms. It simply says, it repeats the general obligation as international law for states to settle their disputes by peaceful means. That's set out in Article 2.3 of the United Nations Charter. And there's also a cross-reference there to the various means that Article 33.1 of the Charter lists as such peaceful means. So I've given you there another quotation at the second half of the screen. So the last 3 lines, it's a long list of things that states can do when they are in dispute in order to solve it, negotiation, inquiry, etc. And you'll see that arbitration and judicial settlement are the most legal, shall we say, of those means that are included within those lists, or within that list. But the point is that the means must be peaceful, so no resort to arms, and it's a completely free choice. So even if something is not in the list, that's not a reason for the states not to choose it if that is their preference. Then we come to Article 280, and this sets out that this free choice of means is in fact the first rule that states encounter on the way to settling a dispute. And what I mean by that is that everything else that follows is really a kind of default answer to the question of what happens when the states concerned have not made any other choice, which they're always at liberty to do. So let's assume that they've chosen some means other than Part 15. Those means may not work, and if that's the case, then Article 281 would allow the states to come back into Part 15 unless the agreement to do something else, to contract out of Part 15, excludes any further procedure of that kind. And we don't have time to go into the details, but Article 281 turned out to be crucial in both the southern bluefin tuna case between Australia and New Zealand and Japan 20-odd years ago, because of the presence of another treaty where it was rather controversially found to have impliedly excluded recourse to Part 15 of UNCLOS. And this was a point raised by China in its unofficial memorandum in the South China Sea arbitration some years ago. It was relying on the SBT case, but I think correctly the arbitrators in that later case found that although it is possible to contract out of Part 15, the only way to do that is expressly by treaty. So impliedly there they were overruling the SBT holding. Well, so far we've been dealing with situations where the states have chosen some other means that does not, means of dispute settlement that does not lead to a compulsory outcome that is binding on the parties. But in Article 282, what we are faced with is the possibility that the choice that states have made to go outside Part 15 is in favour of something that does in fact amount to a compulsory procedure with a binding decision. And in that case, Article 282 says, well, that's what you do. So it generally favours the notion of compulsion. And if that's what the states have decided to do, then that is, according to Part 15, what they should do. So for those of you who know about the so-called optional clause that governs access to the International Court of Justice, this means that where declarations coincide, that would continue to apply at the expense of Part 15, although for our purposes today, that's not really a major concern because of the various other international players that might conceivably find themselves in a case with Sri Lanka. It turns out that India has made a declaration, but Sri Lanka itself has not, and the European Union can't because it's not, in fact, a state. So we don't need to worry any further about the ICJ. And then the last preliminary here is Article 283, which is also about jurisdiction, but in a procedural sense, that when a dispute arises, you don't simply litigate at the drop of a hat. You must first exchange views on how to settle the dispute with the other side. And in the cases that we've seen over the years, there has developed something like a ritual in which the respondent, the defendant, will almost always argue that Article 283 has not been complied with. And equally ritually, the court or tribunal will say, yes, it has in fact been complied with because it's not a particularly onerous obligation. And in particular, there is no obligation to prolong discussions or negotiations endlessly when the applicant state has reasonably formed the conclusion that there's no point in continuing that conversation. So even in the one case where it could well have been argued that Article 283 was not in fact complied with, even there, the court found that it wasn't an issue. So it's not really an obstacle to the jurisdiction of courts in practice. Well, let's turn then to the cafeteria, so-called, in Article 287, and this is what makes Part 15 rather complicated. It's because states are given, in essence, 4 choices of forum for settling their disputes about UNCLOS. And I've brought them up all at once. So the first is the International Tribunal for the Law of the Sea. Secondly, the ICJ. Thirdly, an Annex 7 arbitral tribunal. And fourthly, a special arbitral tribunal, so-called under Annex 8, for 4 categories of subject matter into which a dispute may fall. So if it falls into one of those 4, then an Annex 8 tribunal will be one of the choices. Otherwise, you're restricted to the other 3. And in terms of the subject matter that we're discussing today, it so happens that both of them would potentially fall under Annex 8. One is fisheries, and another is navigation, including pollution from vessels. So the Pearl Express might well be an example of something that could, if the circumstances were right, eventually fall under Annex 8. Now, these declarations are voluntary, so less than a third of the 160-odd parties to UNCLOS have made declarations. And again, we find that none of the players have actually made one. So we are dealing today purely with where the dispute may end up by default. Well, because there were no declarations, it's really academic to say it, but I'll say it nonetheless, that supposing that the parties have made the same choice in their declarations, then that is where the dispute will go. But if they haven't, if they've made differing choices, or indeed if they've made no choice, which is the case here, then the default option is going to be Annex 7 arbitration. So an ad hoc arbitral tribunal is where currently any dispute involving Sri Lanka under UNCLOS would go. Now, it's always open to the parties once the Annex 7 tribunal path has been begun to agree with the other side that we should really go elsewhere, but that tends, it's happened a couple of times, but it's fairly rare. Let me then also mention that Article 288, which we can skip over very quickly, that's simply the provision that says, well, once you've made the choice and you've complied with the various procedural provisions earlier, then the court or the tribunal chosen will in fact have jurisdiction over the dispute. If it's a scientific or technical dispute, then Article 289 also opens up the possibility of experts being invited to sit alongside the court or tribunal, but they don't actually get to vote on the outcome. They're simply there to make sure that the decision handed down is not scientifically or technically illiterate or absurd. And then lastly, Article 296, once you've gone all the way to a decision on the merits, then that is final. It's binding. There is no possibility of appeal. On the other hand, its binding force is confined actually to the parties before the court and only to that dispute. So that's a long-winded way of saying that in international law, there is no doctrine of binding precedent, which is not to say that precedents are not cited before courts. They often are, and they're usually followed, but they are evidence of the law. They're not a source of it, as they are in common law systems. Now, I said I'd introduce provisional measures, and that's in Article 290. So this is the international law equivalent, if you like, of an interim injunction to preserve rights of the parties while the case is being heard, and preventing rather serious harm to the marine environment is another reason for which these measures can be sought. There was particularly in pre-UNCLOS days, there was a long controversy under the ICJ statute as to whether provisional measures were in fact binding, but in 2001, that question was resolved in the affirmative. And in order to avoid this uncertainty, the negotiators wrote into Article 290 that at least under UNCLOS, these measures would be binding. Now, obviously, if the circumstances that led to their being prescribed have changed, then they can always be modified or revoked, and that too has happened a couple of times. Now, you might ask yourself that because we're going by default to an Annex 7 tribunal, and that has to be set up from scratch, what do you do if you want provisional measures from a tribunal that does not yet exist? And the answer to this is that ITLOS, the Law of the Sea Tribunal in Hamburg, is given that jurisdiction by default. So until such time as the tribunal exists, ITLOS has the jurisdiction, and then very frequently you find, and I've given some examples at the bottom of the screen here, that a case begins before ITLOS for provisional measures, and then the merits are ultimately heard by an Annex 7 tribunal. So quite a number of times that has happened. And I'd be happy to answer questions on it in the Q&A, but meanwhile we need to move on. So Article 292 is the other thing that might conceivably come up relating to the fisheries or indeed pollution matters around Sri Lanka. If it occurs in the exclusive economic zone. So Article 292 is a unique procedure provided in UNCLOS for getting vessels that have been detained promptly released. And the rationale behind it is that when there is an obligation elsewhere in UNCLOS to release a vessel promptly on posting of a reasonable bond or other financial security, then the question of whether that obligation is being met by the port state or the coastal state can be taken separately in a one-off proceeding, again to ITLOS as the default jurisdiction. And the only issue in proceedings of this kind, which ITLOS is directed to give priority over everything else that might be on its docket, is whether the bond has in fact been set at a reasonable level, assuming it exists. And all of this is meant to be without prejudice to the underlying dispute, the proceedings in the national courts against the vessel, the owner, or the crew. Well, that is how it should work. Arguably, in some of the early cases, it didn't quite work like that. So the Monteton Furco case has come under quite a bit of criticism for ITLOS essentially involving itself unnecessarily in the merits of the dispute. The other thing that can happen is that even while all these proceedings are on foot, it's always open to the port state to release the vessel or crew from detention. And in fact, the Volga case is of 2002 is an example of that happening, which didn't bring the proceedings to an end, but did in fact make them somewhat simpler. And lastly, we have the two exceptions, and Article 297 is an automatic exception for, among other things, fisheries-related disputes in the EEZ. And because we're a little bit short of time, I won't take you through the exception to the exception. I think it's enough if I point out that there is some scope for instead going to compulsory conciliation, which is a rather odd kind of beast. So it's a compulsory process, but it leads to an outcome, a report that is not itself binding. And it depends on one of three allegations being made. Essentially that the coastal state is not looking after its fisheries resources properly in the way that is set out in a different part 5 of UNCLOS. The Conciliation Commission is kept on a short leash, so it's not supposed to, to report, substitute its own discretion for what the coastal state has done. And as I said before, it produces a report, but the report itself is not binding. It's up to the parties to decide whether or not to act on it. And lastly, Article 298, an optional exception. And there's three, but I think only one is relevant to us today. And that is for either military activities or law enforcement activities that are related to the Article 297 exception. So if it were fisheries, then anything that Sri Lankan authorities might do by way of law enforcement in the EEZ is equally subject to this optional exception if that is invoked, but in fact Sri Lanka has not invoked that exception, so it wouldn't in fact apply. But the other thing to be said about Article 298 exceptions when they are made is that they operate reciprocally. So if a party has made an Article 298 declaration, then not only can it not be sued, equally it can't itself sue another party to UNCLOS unless the consent of that party is obtained. And any proceeding that has already begun would not be affected by the modification or withdrawal of a declaration. So that's the first half of my talk today, and then the unrelated or largely unrelated second half relates to IUU fishing. And here what I hope to convince you of this evening is that this entire concept of IUU fishing is in many ways flawed. One can make a great number of criticisms of it, but I think they all boil down one way or another to the main problem being that it's something that's presented as a single phenomenon. We talk about IUU fishing, but then when you look at the definition, it's at least 3 and possibly as many as 7 separate problems. And arguably, it would be far more sensible to treat those problems separately by way of differentiated policy responses. Well, unfortunately, that's not what the international instrument does. So in 2001, the Food and Agriculture Organization of the United Nations adopted the so-called International Plan of Action to Prevent, Deter and Eliminate IUU fishing. And if you read it from beginning to end, you'll see that apart from one provision which talks about a particular sanction that might be applied to the products of illegal fishing, the other 70 or 80 paragraphs all treat it as a single one-size-fits-all problem, so that it makes no distinction apart from that one that I mentioned between what is illegal, what is unregulated, and what is unreported. And this is problematic because particularly the two at either end of the IUU acronym, I don't really need to tell this audience or to convince you that there's a world of difference between an activity, in this case fishing, that is really illegal because of some law that a legislature has passed, and fishing that is merely unregulated. And I think the underlying problem here is that they thought they were troubled by unregulated fishing, but in fact, what I'd suggest is that what is really behind this is that the unregulatedness of fishing, where that persists. So where there are no rules, what they ought to be doing is making the rules, and then if those rules are contravened, that is what is illegal. But it's an illegitimate shortcut to pretend that something that is merely unregulated is exactly the same as something that is illegal. This is, I think, gradually becoming apparent to the international community, but it's taking rather longer than one might have hoped. Now, what I'm going to do on this next slide is bring up the entire definition of IUU fishing in Article 3 of the FAO Plan of Action. And depending on what size screen you have, you may well react to this by saying you can't possibly read it. And that, in a way, makes my point. Because if the central concept that you of any piece of legislation takes this many words to define, then that, I would suggest, is a sign that something has gone wrong. So on the next few slides, I'll just show you very quickly, I'll break it down into the individual components. So there are 3 components of illegal fishing, and you'll see here that it's dependent on the law of the coastal state. That's certainly true of 311 and 313. So some of the problems that were referred to in the introduction before about the waters between Sri Lanka and India, this is contravention of the fishing laws of Sri Lanka, domestic law, and this illustrates the underlying point that illegal fishing is not really a question of international law as such. It's about the enforcement of national law, in this case, Sri Lankan law. Turning then to unreported fishing, this has 2 elements, so we're up to 5 in total by now. And unreported fishing doesn't really fit very neatly into the scheme, but the way I would see it is this is fishing that would be lawful otherwise, but some reporting obligation has not been complied with, and that in itself is a kind of secondary source of illegality. So I don't have a problem with illegal fishing. I don't really have a problem with unreported fishing either, because that is secondarily illegal. The problem, as I mentioned before, arises here. Unregulated fishing, the last 2 elements, 331 and 332. This is fishing that, well, it's rather vaguely defined. For lack of time, I won't stop and I won't dwell on the actual definition of it. But what I would point to is the next paragraph in the IPOA, which is 3.4, which is a vital but often ignored qualification. And here it's much shorter. It says that it recognises that certain unregulated fishing is not actually a problem and may not require the application of any of the measures that you find in the rest of the IPOA. Now, if states took this to heart, I think that would be a good thing, but unfortunately that is more the exception than the rule. And so what I'm about to show you next is the paper which the European Union, or the European Community as it then was, used in 2007 to launch the process that eventually led to the regulation that currently governs importation of fish into the European market. So if you look at the words in italics and the words around them, then what you'll see, references to fisheries that are legal. The next one is fisheries crime, theft, and one more, disregarding obligations of legal operators. So we're talking here about IUU fishing as a whole, and yet all the rhetoric is about, or is based on the assumption that this is in fact illegal fishing. And as we've seen, some of the fishing will in fact be illegal, but by no means all of it. And the question therefore arises, should we treat the product of all IUU fishing the same way in terms of subjecting it to the risk of trade restrictions? So that was a political document, you might say, but then you turn to the regulation itself of 2008. So this is the one that establishes the possibility of trade restrictions against the product of IUU fishing. And the EU has really adopted almost verbatim the definitions of the components, illegal, unreported and unregulated fishing, in Article 2 of the regulation that follow Article 3 of the FAO International Plan of Action. But conspicuous by its absence is any reproduction of that crucial qualification I showed you before in paragraph 3.4, the one that says that not all unregulated fishing is necessarily bad. And if you delve into the text of the regulation, in particular the preamble, which I've put up here, and again, we still have this assumption that transshipments are bad. Why? Because they are a way of disguising the illegal nature of their catches. Well, illegal is only part of the problem. What about unregulated fishing? Should we assume that unregulated fishing is equivalent to illegal fishing? And my answer to that remains no. So this is my last slide, and I just wanted to bring out here that some ideas on how this might ultimately impact in the real world on Sri Lankan fish exports to the European market. So if this Damocletian sword is hanging over all exporters, including Sri Lanka, under the IUU fishing regulation, then one possible ray of good news is that because of the absence of any equivalent of Article 3.4, there might be a possibility to challenge a trade restriction before a WTO panel in Geneva. And the reason I say this is because the EU, by definition, because this is unregulated fishing, there is no regulation to stop European fleets from doing exactly the same as Sri Lankan fleets are doing, fishing fleets are doing. And that means that it doesn't qualify, whatever measure it might ultimately take, including the IUU regulation and the particular restrictions that might apply under it. These measures would not qualify for the general exemption under the GATT, the General Agreement on Tariffs and Trade, administered by the WTO, which benefits measures that relate to the conservation of exhaustible natural resources, including fish. So this discipline, if you like, is something that might be holding back unhelpful trade barriers. But I'd end on a note of caution, which is that for the last couple of years, the WTO has been negotiating on the subject of fisheries subsidies. And rather regrettably, a large part of the current text, which in fact might have been adopted by ministers had the latest ministerial council not been postponed at the beginning of this month, in fact relates to IUU fishing. So the WTO, which until now has stood as a kind of bulwark against excessive application of the undifferentiated notion of IUU fishing, well, we may be about to lose that in the short to medium term, which I think would not be a positive development. So let me end there, and I think we're not going to questions immediately, are we? But if we are, that's fine. If not, I'm happy to take them at the end. So thank you very much for your attention.
Thank you, Professor. No, we're not taking questions at the end of each segment, but we'll do a Q&A session right at the end. And due to the time limitations, I would like invite Mr. Mehta to begin his presentation.
Thank you very much, and it's a privilege to be invited to speak. I've done a version of this topic recently to about 200 environmental lawyers in the UK. It lasted all day. Another version I did about 3 years ago to about 500 judges in Brisbane from all over the world, and that lasted half a day. So it's a challenge to do a version of it in the next 15 or so minutes, but it's liberating as well, because it liberates me to not condescend to the level of detail which I don't think those participating would want me to, and therefore I can assist with an overview. As a result, I've had to change the slides quite a bit. And really, what I want to focus on is some 7 suggestions that I would make as a result of my own experience in prosecuting these cases for the last 25 to 30 years in this country, and the lessons that have been learnt in the UK and in Europe. And the reason I think I want to focus on that is I understand that Sri Lanka may be looking at new laws or new versions of existing laws to deal with waste dumping. So can I start off then by just dealing with the 7 suggestions, and each of the slides after this first one, I will try to connect to one of these 7 recommendations to those who are thinking about drafting further legislation in Sri Lanka. So the first suggestion, and the slides don't deal with this directly, is try to make sure that those who have the duty to investigate and enforce the law, if we can just stick to the slides at the moment, please. Those that have the duty to investigate and enforce the law are given wide powers. The lesson we've learnt in the UK is that the Environment Agency has been given relatively wide powers, partly because it wears 2 hats, one hat as a regulator and the other hat as a prosecutor. And in its hat as a regulator, it has the power to go into premises, to ask questions, to seek information in writing. And then that is usable, depending on the particular law of evidence that the defence may want to use. It's usable by the prosecution in a prosecution. So wide powers is my first suggestion. I'll tie it into the slides as we go along, but let's stick to this one. The next suggestion is mens rea, so the mental element in the crime. By and large, environmental offences, and certainly almost all waste offences in Europe and the UK, do not require mens rea, do not require the mental element of a crime. The usefulness of that is that it makes it much easier to prosecute. Now, of course, there's a human rights element to that, and a human rights lawyer would suggest that that's unfair and that every criminal offence should require mens rea. I can tell you that I'm a founding member of the Bar Human Rights Committee, and therefore I often grapple with those 2 conflicting ideals. My own view is that given the importance of the environment and the importance of protecting the environment, this is a limited and rare area in which the legislators can legislate without the need for mens rea. My third suggestion for legislators is try to catch everyone in the chain, or as many people in the chain as possible. What I mean by that is try to make sure that the law applies to those that collect the waste, those that sort the waste, those that handle the waste, those that deliver the waste from the producer's factory or site to the dockyard, the shipper of the waste that takes the waste away to Sri Lanka or Africa or Singapore, as I recently prosecuted. Try to make sure that everyone in that chain is caught, in speech marks, and then it's up to the prosecutor to use his or her discretion as to where the fairness lies and who should be prosecuted amongst that chain. Fourth, try to make sure that the law has easy definitions and easy to understand definitions. The reason I say that is that Europe has spent probably a good part of 20 years in even defining what waste means. We've now got to a much better place as partly as a result of litigation in Europe, partly a result of one or two of the cases I've taken in the Court of Appeal. And of course, as you'd expect, judges by and large initially are appalled at how complex the area of waste litigation is, but also are amenable to making sure that judge-developed case law makes it easier for a jury to understand in the UK particularly, or for legislators to understand, and the public also to understand what exactly they're doing wrong, what the definition of waste is, and other elements of the offending behaviour. Fifth suggestion, sentence. We have had recently in the UK sentencing guidelines to try to standardise sentences across the country, because particularly with environmental offences in one part of the country, you might get very lenient sentences because the local industry depends on the particular matter that's been prosecuted, whereas in other parts of the country, for example London, you might get judges sentencing much more severely for identical cases on identical facts. And so sentencing guidelines have helped, and it also ensures that the legislators can make sure that the judges treat these offences with the seriousness they deserve, because the guidelines require the judges to go through each of the points of the guidelines to ensure that level of sentence. The next point, number 6, is confiscation. Confiscation has been a growing and major developing area in the UK, but also in Europe. It is particularly useful in environmental and in waste matters, because, of course, at the end of the day, those who benefit from waste dumping and from environmental offences are doing it because they want to make money. And this is an area where there is a huge scope for making large amounts of profit, and therefore confiscation of the assets of the offender, whether it's boats that they've been using, or whether it's the equipment that they've been using, or the money that they've been putting into their bank accounts. That is where they're most vulnerable, and it sends strong signals across the industry. And certainly some of the cases that I prosecuted has sent shockwaves across an industry who thought that they were completely immune from the state's long reach of their bank accounts. And finally, point number 7, consider the legislators deciding this in Sri Lanka, the question of compensation. Now, compensation, of course, is a concept that all civil lawyers are used to. But of course, in the UK, particularly compared to Europe, we've been using compensation as a tool to protect the environment after the offence. So in one of the cases that I prosecuted involving water pollution, the judge was able to effectively force the defendant to compensate the local charities whose job was to upkeep the river, and they benefited to the tune of many millions of pounds. So those are the 7 broad points that I want to address, and in fact I suspect I've already gone halfway through my talk as a result. So the first slide, and I'm now going to rattle through the slides. This is an important area. Since the Industrial Revolution, in fact, those in the West who've been the greatest beneficiaries of the developments since the Industrial Revolution have been creating waste on a large and increasing scale. The whole of the world, in fact, has been increasing its waste production. And of course, as you'd expect, those that create waste are the ones with power, with the money, and therefore the politicians and the law has, in the West at least, traditionally sided with the creators of the pollution. I'm sure it's very different in Sri Lanka. But that's been the lesson of the development of the law in this country until things came to a head in the 50s and 60s. And it became abundantly clear that the West was exporting its own problems, the huge amount of toxic and non-toxic waste that it was creating through its own industrial process and through the act of the Western living. And the waste was being exported to other countries, and usually they were the developing countries, the non-OECD countries. And things came to a head, particularly in the 60s, and international conventions started to be drafted to limit that. If we could have the next slide. So here's an example of where there is a problem with the law or the understanding of the law. So here you've got TVs, and one of the first big cases that I prosecuted involved 22 defendants at each part of the long chain of export of electronic waste. This particular waste was going to Africa, to one of Africa's biggest electronic markets. Now, as you'd expect, there is nothing wrong in the export of working, good quality, second-hand electrical waste, as we in the developing countries are using more and more things of this sort. Rather than dumping working TVs or working stereos, it makes good sense that if they're in good working order, someone else elsewhere in the country, elsewhere in Europe, or in this case in Africa, might want it. The mischief is the difference between TVs, in this case, that work, and you can see that on the face of it, these TVs look perfectly okay, and this is what an Environment Agency officer or the customs would see. And the next slide, apologies for the noise in the background, I live opposite Parliament, and as always, there are huge demonstrations going on outside Parliament, so apologies for the noise. Here's when you take out the TV from often the second or third row on the huge 40-foot containers that go across from the UK to Africa. There's an example clearly of a TV that cannot possibly work. Now, in one of my early cases, we had the BBC, British Broadcasting Corporation, who were doing a documentary, and so they were allowed to join in with this investigation. That's what I mean about broad investigative powers. They actually made sure that a TV like this was opened up, an expert dismantled it, taking the heart out of the TV so that it could never work or be made to work, put a transmitting device into it, and followed it. And we, in my prosecution, were able to use all of that evidence despite the defense attempt to exclude it. And so you can see how powerful the evidence would be to prove a TV like this not only didn't work, but we could trace exactly where it went to and the particular market in Lagos that it ended up in, to prove the whole chain of events and to prove the case against every single person in that chain. If we could have the next slide, please. Here's an example of two recent cases that I prosecuted, both of which ended up in the Court of Appeal, and the law has moved slightly in relation to the export of waste. I was prosecuting one of the UK's biggest waste export companies. It's also the UK's biggest collector of waste. It's called Biffa Waste Services Limited. It's the group of companies is a multi-billion-pound group of companies, and you can see there that the Environment Agency officers trawling through a number of shipping containers. And you can see how on the face of it, it looks like what is being exported is largely waste paper. In fact, that's what the documentation said. And then if we go to the next slide, please. You can then see when you separate out in that ton of waste that was being inspected by the officers, in fact, a good proportion of it is plastic, is food waste. There was even, there were bags of excrement in there, some clinical waste and the like. And if we go to the next slide, we were able to show that in an average ton of waste that was, or waste paper that was purported to be exported by this company, we found something up to 10 nappies per ton, ranging between 3 and 10 nappies. And by our calculations, the company therefore on an annual basis was exporting about 340,000 soiled nappies a year. So you can see the size of the problem, but also it was the jury that had to decide in this case whether what was being exported was just good quality waste paper, which is perfectly permissible. In this case, they were exporting to China in the first case, in the second case to India and to Indonesia, or were the defendants exporting what was either badly sorted household waste or unsorted household waste? And this is an example of how, as a prosecutor, I was able to show with the officer's assistance that, in fact, when you look at all of the contaminants in the so-called waste paper, and the number of nappies is just an example, number of plastic bags, and the food waste a further example, that in fact the jury was able to build up a picture that this was not waste paper, that was just household waste. And one thing that assisted me as a prosecutor in this prosecution was that the definitions were kept very simple. And in fact, we had to go to the Court of Appeal on one occasion, just before the start of this case, to simplify the definition in relation to one aspect of waste. And so that ties back to my suggestion to the Sri Lankan legislators to try to keep the definitions as simple and easy to understand for the court as possible. If we can then go to the next slide, please. So this is the Bâle Convention, or the Basel Convention, depending on whether you're middle class or working class in your pronunciation. And this was the start of the movement, international movement, to try to limit the waste that was moving from the developing countries to non-OECD countries. And of course, it's a constantly moving target. And so even as recently as 3 weeks ago, we had the COP26 meeting in Scotland, just up the road from London, where I am. And of course, the transboundary movement of waste was an important aspect of that conference, because more and more the receiving countries are saying this is not what we want, this is not what we signed up to. And the more research that's being done, we've discovered that, for example, in villages in China, where some of the so-called waste paper was being sent, when the factory that receives it uses the local youngsters and the poor people to sift through the waste, the plastics that they find and other contaminants then tend to get burnt. This we found in Africa with electronic waste, in China with plastic and other waste, and also in parts of India. And of course, one can only one doesn't need to imagine the level of ill health that's caused. Cancer rates rising locally with this sort of burning, particularly of electronic waste. Ill health in local communities. If we then go to the next slide. As a result of the Bâle Convention, the European Union then decided to take action. You can see that Article 192 of the Consolidated Treaties says that Union policy on the environment shall aim at a high level of protection. It should be based on the precautionary principle, and the precautionary principle is of great use in European environmental legislation, and of course the UK has adopted that. Basically, the precautionary principle makes sure that if there are 2 or 3 or 4 ways of looking at something, what the court should do is also always start off with what is the safest, what is the way of looking at something that saves the environment and is least harmful to human health, rather than any other definition. And so the precautionary principle is widespread and is used in a number of ways, and the example I've just given you is just one of many. And the next slide, please. And then we come to the actual legislation. This is an old piece of European legislation. It's now been updated, but the principles are still exactly the same. And some would have thought, particularly given what I've said about those that produce waste, having controlling the means of production, having control politically as well. Well, Article 1 was to some extent revolutionary, because it says that that the protection of the environment takes precedence over international trade. And therefore, one can see how Article 1 sets the scene for the new agenda on protecting our own environment and environments elsewhere that receive our waste as much as possible with the precautionary principle, and also to make sure that any complaint about the effect on international trade is only secondary or tertiary. The next slide, please. And then we have the UK legislation, European Shipment of Waste Regulation. Again, every few years there is an update to this. It allows some waste to be exported, and so there's a traffic light system. There's red on the traffic light, which can never be exported because it's just deemed too harmful. And so, for example, household waste, which are some of the cases I prosecuted, are on the red list. And then you've got the green list and the amber list. And so there are some waste that can be exported, and then on the amber, subject to a number of requirements of reporting, some of those sorts of waste can be exported. And so one would have to go trawl through quite a long list, and it is an exhaustive and exhausting list that one has to go through if one were to export waste material abroad. The legislation requires waste to be exported only on notice, and allows the recipient countries to say which waste material cannot be received. And so at the end of one of my prosecutions of waste being exported to China, the Chinese authorities, who initially were not keen to engage, by the end of that prosecution, because we were liaising with them throughout, became fully aware, or better aware at least, of how much unwanted waste was coming in through their system, even though their paper mills could deal with it. They therefore changed the law. Now, I'm not suggesting that was a direct causal connection, but it was one of the factors that caused the Chinese to change the law within weeks of the ending of our case, which would have then prohibited those sorts of waste materials being exported from the UK. Sadly, as a result of that change in law, the company that we prosecuted started sending their waste material to other countries that didn't have the more stringent version of the Chinese law. If we can then move to the next slide. And so this again, I'm going to go through this slide very quickly. The export of waste to non-OECD countries is banned, and one can see Article 36 in the European legislation and Regulation 23 in the UK equivalent of that legislation. I don't think I need to trouble you by going through the details of that. Could you have the next slide, please? And so, in summary, the UK law on waste export says as follows: the shipment starts at the point of loading. So even though a ship has not started sailing, the shipment has already started in law. Anybody involved in the whole chain can be caught by the law. And so in a series of prosecutions that I've been involved in, we were thinking of prosecuting the shipping company itself. And in relation to one of the offenders, the shipping companies now know that if they continue to ship waste of that sort for that particular offender, they may well be on the indictment in the future. Next, it's a strict liability offence, so no mens rea. Next, 2 years imprisonment or unlimited fine. There is now discussion about increasing the sentence, but it's the unlimited fine that is of use, because often it's the companies and the directors that are in the dock, and therefore the use of an unlimited fine is a useful sanction. And then the final point, the proceeds of crime, and I think the next slide is possibly my final slide. And may I just spend 1 or 2 minutes on asset chasing and confiscation. So as I said at the outset, it's a system that is relatively new in Europe and in the UK. Confiscation generally is relatively new here. And the purpose of confiscation is to make sure that those that benefit from criminality have their benefit taken away by the state. That is applied very well in the prosecutions that I've been involved in, whether it's water pollution or export of electronic waste to Africa. So in my latest case involving export of waste to India and Indonesia, I think we sought confiscation of something in the region of £200,000. And the defendant knows that if we prosecute again, the confiscation we will seek will be in the many millions of pounds. And of course, as you'd imagine, boats can be taken, cars can be taken, equipment that's used in the production of the waste can be taken as well. I know that one burning issue relates to, and in the introduction, I heard about the boats that were taken in relation to one of the pollution incidents in Sri Lanka. What I've suggested in a case in the UK that hasn't yet got to court is that when you have a depreciating asset, like a boat or a car, any vehicle, what the prosecuting authorities may want to consider is, with the court's permission and often with the defendant's involvement to price that asset, to forecast its reduction in price, to persuade the court that it's better to sell the asset now rather than in 2 or 3 or 4 years' time when the trial will be heard, and that the money that's raised from that asset from a present sale can be kept in an interest-bearing account, so that even, heavens forbid, if the defendant's acquitted, the defendant will have more money as a result because it will be given back to him than the depreciating asset, which may be worth nothing. But of course, from the state's point of view, by selling the asset initially, it saves on the cost of keeping the asset and maintaining it. And of course, it ends up earning interest in an account that the state will eventually hope to confiscate. So those are my very brief comments on UK legislation, and also my suggestions for Sri Lanka if there is a move to change the legislation in the future.
Thank you, Mr. Mehta. Can we, since we are like right at the edge of the time limitations, can I please ask Ms. Neville to start her presentation? Thank you.
Thank you, Mr. Jayasundara, and thank you to the Bar Association of Sri Lanka for inviting me to speak to you today. If I could have my slides up, please. Anne was doing that for me. What I'm going to talk about today is how gaps in the law contributed to the Express Pearl disaster. Now, if I could have the next slide, please. Minding the gap is well known to users of the London Underground, as we all know it as the Tube. Travellers are reminded to mind the gap between the train and the platform, the gap through which the unwary person can fall or trip. And that seemed to me to be an apt metaphor for what we're going to talk about today. I'm sure that many of you are aware of the key details already, but to set the scene, I return to them briefly. The Express Pearl was a Super Eco 2,700 class ton container ship, which is a feeder vessel. It was a very new vessel. It was less than a year old when it sank off the coast of Colombo in on 2 June, I should say, this year. It entered into service in February 2021, and it was completed in September last year. Its flag state was Singapore, and it was operated by Express Feeders, a container shipping company which operates out of Singapore. If I could have the next slide, please. Investigations are still ongoing, but what is believed to have happened is as follows. Now, I've taken this account from a report of the UN Environmental Advisory Mission, which was commissioned by the UN Environmental Protection Agency at the request of the Sri Lankan government. And this was published in July this year. So I've taken some of the facts from that and some of the pictures that I'll show you, and also from various media reports. So what happened was this: a nitric acid leak from a container was discovered on board the vessel while it was in Hamad Port in Qatar. But the authorities there refused the ship's request to discharge the container. The Express Pearl subsequently departed from that port to Hazira, India, where it docked and again requested the authorities to discharge the leaking container. And this request was again denied. According to one account, both ports claimed that they lacked the manpower and equipment to discharge the container. Consequently, on the 15th of May, the vessel departed for Colombo with the container still on board. And just after the 20th of May, it anchored within the limits of the outer harbour of Sri Lanka, of the Sri Lankan Port Authority. Now, at this time, the vessel was carrying 1,486 containers. That's 1,486 containers. Sri Lankan authorities alleged that the master, the local representatives of the shipping company, and the shipping operator all concealed the truth about the situation on board from them. Later that same day, fumes began to appear from the ship, and Sri Lanka's incident management team was activated. They expected the ship on 21 May, and a directive was issued to the shipping company to take action. However, events rapidly overtook them. On the 22nd, the next day, there were loud explosions in the cargo and the ship caught fire. A salvage company boarded and attempted to control the fire on the 24th of May, but to no avail. Fire finally engulfed the ship the next day on the 25th of May, and multiple containers fell overboard. There were no human casualties. The 25 crew were evacuated. And according to a recent report, a number of them have been detained to assist with investigations and are not allowed to leave Sri Lanka. And the Russian master was arrested and released on bail on suspicion of committing offences under the Marine Pollution Prevention Act. Well, coming back to the fire, what happened there? Well, that was only brought under control 6 days later, on the 31st of May. The decision was made by the authorities to tow the vessel out to a refuge area 50 nautical miles offshore. However, the vessel never made it. Shortly thereafter, on the 2nd of June, while it was being towed, it sunk. And this was around 9 nautical miles from Colombo, as I've mentioned. By the 17th of June, the vessel had sunk almost completely to a depth of about 21 metres, and only the upper forecastle deck and a crane are showing. And you can see that on the after photo that I have there on the slide. Now, the fire and the sinking of the vessel and the subsequent marine pollution are considered to be Sri Lanka's largest maritime disaster, as has been referred to previously. According to the UNEP report, the principal environmental issues arising from the incident include a potential spill of 15 products classified as dangerous goods into the sea, and this includes 25 tonnes of nitric acid. And of the 1,486 containers carried by the vessel, 81 were carrying dangerous goods. A second issue identified by the report is that large quantities of plastic pellets, or nurdles, which is the term used for pre-production pellets that go into a large number of everyday products that we all use. Large quantities of these washed ashore on the west coast of Sri Lanka. And there were around 87 containers containing an estimated 1,680 tonnes of plastic pellets. And it's reportedly the largest plastic spill of its kind on record. However, it has not been the first. Last year, a broken container on a cargo ship lost 10 tonnes of such pellets in the North Sea. And in 2018, South Africa suffered significant harm after a container of plastic pellets fell from a ship in Durban. I'm also going to refer a bit later to the Rena incident in New Zealand, which also involved a container vessel. And according to the reports there, some of the discharges into the sea included plastic pellets there as well. Latest reports in November suggest that only around 1/3 of the split plastic pellets lost from the Express Pearl have been gathered by cleanup teams. And the third issue that I'm just going to briefly mention is that the sinking also involved a bunker fuel spill. Now, bunkers is the term used to refer to the oil that's used to power the vessel, as distinct from the oil carried by a vessel, and I'll come back to that too. If I could have the next slide, please. A report published in October attributed the deaths of 417 sea turtles, 48 dolphins, and 8 whales to the Express Pearl incident. And it's reported that the livelihoods of around 20,000 fishing families are badly affected by the damage, including because of fishing bans imposed because of the health risks caused by the pollution from the vessel. And I find all of these photos, which I've taken from various sources in the UNEP report, really distressing to look at. It's staggering the extent of the damage that we're looking at here. As you would expect, huge compensation claims followed. Express Feeders, the vessel operators, made a US $3.6 million interim payment to the Sri Lankan government to help compensate those affected by the disaster in July. And this was said to be part of an interim claim of around US $40 million. Express Feeders has reportedly received another compensation claim demand from the government this month, which is said to be being reviewed by its insurers. It's also reported that the Centre for Environmental Justice, an NGO, has launched proceedings against the Sri Lankan government and the shipping company for their roles in the situation. And it's also reported that the Supreme Court this month gave leave to commence proceedings against a number of authorities for allowing the ship into Sri Lankan waters. So as you can see from this account, a number of different actors, including the commercial operators, but also government authorities, are in the firing line. The proceedings before the Sri Lankan courts proceeded under domestic, or will proceed under domestic law. Similarly, how the government has pursued its claims against the vessels' owners and operators and the other commercial entities involved, and how it distributes the compensation will depend primarily on the domestic law of Sri Lanka or that of any other jurisdiction that might be involved. However, Sri Lankan law is not, unsurprisingly, an area of law that I'm qualified to speak to. So what I wanted to touch on was how the disaster sounds in international law. A number of international treaties are engaged, and if I could have the next slide, please. The question is, do they work adequately to protect or address all the environmental damage caused by the express pearl? And if I could have the next slide, please. Thank you. Are there any gaps? I do not have time to explore all the possible treaties that are relevant here, so I'm only going to discuss them by reference to the two main issues that jump out to me from the facts of this case: the damage caused by the nitric acid and the plastic pellet cargoes, and the fact that the damage could have been prevented altogether if the problematic containers containing the nitric acid had been dealt with earlier in the vessel's passage. I start with the cargo. The main treaties here are MARPOL and SOLAS, in particular MARPOL. MARPOL is the shorthand term used for the International Convention for the Prevention of Pollution from Ships. MARPOL was adopted under the umbrella of the IMO, that's the International Maritime Organization. The IMO is an international government organization and UN agency which was established in 1948, and its purpose is to provide machinery for cooperation amongst governments in the field of government regulation and practices relating to the technical matters of all kind affecting shipping and trade, and also to encourage and facilitate the general adoption of the highest practicable standards in matters concerning maritime safety and this is important, and prevention and pollution and control of pollution from ships. MARPOL currently has 5 substantive annexes, of which we are concerned with Annex 3 here, on the prevention of harmful substances from ships, which entered into force in 1992. Harmful substances are those which are identified as marine pollutants in the International Maritime Goods Code, the IMDG code. Carriage of harmful substances is prohibited except in accordance with Annex 3. And each government is obliged to issue detailed requirements on packing and packaging of the harmful substances. Packing is required to be adequate to minimize the damage to the hazard to the marine environment, having regard to the specific context of the dangerous good or the marine pollutant. The shipping documents carried by the shipper are required to include a declaration that they are properly packaged and labelled and in a proper condition for the carriage and stowed in a way to minimize damage to the marine environment. The ship carrying the cargo is required to have a special list or manifest setting out the harmful substances which it carries on board. And this is to be made available before departure to the state authority. Whether the vessel is obliged to advise the ports it is calling at in advance of its arrival of the cargo it is carrying, and including its dangerous goods and marine pollutants declaration, will depend on local law. So, for example, the Port of Southampton in the UK requires notice and a copy of the manifest to be sent to it at least 24 hours before the arrival of the vessel. Now, the code that I referred to, the IMDG code, was introduced in 1968 to list the dangerous substances governed by the Convention on the Safety of Life at Sea, or SOLAS, and it was expanded later to include harmful marine pollutants for the purpose of MARPOL Annex 3. Now, the devil here is in the detail. The code is in 2 volumes and it runs to several hundred pages, and is based on a complex UN classification system. So I can't really give you the details here. But in short, forms of nitric acid are classified as dangerous flammable substances and also as a marine pollutant for the purposes of Annex 3. So far, so good. But this is the catch. Plastic pellets are not recorded in the code at all, either as a marine pollutant or as a dangerous good, which means that they are not subject to any requirements regarding packing and packaging and stowing of cargo, or the cargo manifest declaration requirements that are set out in Annex 3. Now, one of the implications of this, it seems to me, is that when you're trying to assess the risk that a vessel and what it is carrying poses to the marine environment, the fact that it is carrying plastic pellets does not, on the face of it, appear to be required to be taken into account. And what I have in mind here is the obligations of parties to UNCLOS, the UN Law of the Sea Convention, to take all measures consistent with this convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source. We might ask, what are the obligations of a port state if a container vessel asks to discharge a container because it is leaking a flammable substance? Container ship fires, according to Maritime Risk International, a shipping industry publication, occur on an almost weekly basis, and the vast majority are caused by carrying cargoes of hazardous wastes. And I'm going to come back to the potential obligations on the port state in a moment. Insofar as plastic pellets are not listed as a harmful marine pollutant in the code for the purposes of Annex 3 of MARPOL, there is clearly a gap in the law. And Sri Lanka, to an extent, has fallen through the gap between the problem of a modern form of good and modern forms of marine transport and container vessels and the existing law. Sri Lanka, to its credit, has raised this gap at the IMO in October this year. It made a submission to the Marine Environment Protection Committee in the context of the action plan to address marine plastic litter from ships, which was adopted by the IMO in 2008. Sri Lanka has called for 6 types of action, including that plastic pellets are listed in the IMDG code, and for the establishment of internationally agreed requirements and implementation guidelines for emergency response protocols in the event of chronic losses of pellets from ships. However, this proposal does not directly address what, if any, obligations states have to respond to a request to unload containers that could cause fires that may cause the vessel to sink in the first place. And this takes me back to the point I was making earlier. In considering any obligations of ports in relation to vessels calling at their ports in transit, it must be recognised how onerous these can be. And I know in this regard that there's the earlier comment that the way that Sri Lanka is working or cooperating with other states involved in the incident is based on collaboration and cooperation moving forward. But I still think it is interesting to consider what obligations port states might have and what law might govern what they should do when faced with a request to unload a damaged container which contains a flammable substance. And we have to recognise that this is a hugely costly operation to all those involved, not just the port, but all the commercial operators. So perhaps all the drivers around an incident will be to resist taking an action for very understandable reasons. Delays cost money. Indeed, allocation of liability and liquidated damages for delays are built into charter party contracts between the parties. But on the other hand, the cost to the environment in not acting can be huge. Now, there are guidelines in place which have been developed under the auspices of the IMO in relation to oil tanker incidences, where, such as the Prestige and the Erica, where vessels in distress asked to call at ports, in this case oil tankers, not container ships such as the Express Pearl, and were denied refuge, and in the event broke up and sunk at sea, causing huge marine damage. And so steps have been taken to address those types of situations. And even the IMO, much to my surprise, recognises on its website discussion of those developments that it's not surprising that ports reject requests of refuge in such circumstances, and that it's in no one's interest or benefit to lay the blame with anyone. But on the other hand, we might want to think about what can be done to address this gap in the law, because prevention is much, much better than cure, especially in cases like the express pearl. If I could have the next slide, please. I've not touched on the issue of treaties governing civil liability and compensation, and in view of the time, I'm going to go through this as quickly as I can. But one of the issues highlighted by the Rena maritime disaster in New Zealand in 2011 was that New Zealand had not signed and ratified the International Convention on Civil Liability for Bunker Oil Pollution of 2001. This was important because the Rena, like the Express Pearl, was not an oil tanker, but a container ship, and the Bunker Convention covers oil spills from ships whose oil is carried as fuel, not oil that is carried as cargo. Nor was New Zealand a signatory to the Convention on Liability and Compensation for Damage in connection with the carriage of hazardous and noxious substances by sea of 1996. A bit of a mouthful there. And this defines hazardous and noxious substances to include dangerous, hazardous, and harmful substances covered by the IMD code. And what this convention does, which is important, is it sets up a fund to make compensation claims against. And the failure to ratify these treaties was one of the subjects of an independent review into the disaster commissioned by Maritime New Zealand and its Ministry of Transport. Now, what the report records was in that case that the parties involved didn't limit the compensation they paid out to the limits in the relevant treaties. So in the event, perhaps it didn't really matter that New Zealand hadn't signed the treaty. Similarly, Sri Lanka is not a party to the Bunker Convention or the HNS Convention. But even if it was a party to the HNS Convention, as I've already mentioned, one of the problems is that plastic pellets aren't recorded as a marine pollutant and hazardous substance in the code. And therefore, all of the damage caused by the pellets wouldn't have been covered by the convention and any event. What these comments demonstrate, both about the absence of provisions governing the carriage of plastic pellets, but also the obligations of parties and ports authorities around prevention of disasters, are that there are still many, many gaps in the law to be addressed, and that the Express Pearl disaster does highlight these. And to conclude, really just with a push for lawmaking, and I've mentioned one already undertaken by Sri Lanka to introduce amendments to MARPOL through the IMO. And there on your slide, and sorry, if I could just have the next slide, my last slide, you'll be pleased to hear. Well, when Anne manages to bring up the next slide, oh, there you have it. You will see that there are two treaties that are being negotiated at the moment, or international instruments, and both of them will have important ramifications for the marine environment. And so it's important for all of us to be aware of them and for governments to get involved pushing them forward. The first is on a convention to conserve and on the conservation and sustainable use of biodiversity in areas beyond national jurisdiction, i.e. beyond the EEZ and continental shelf, covering the water column of the high seas. And the second, which perhaps will have even greater implications for the types of pollution that we have emanating from the Express Pearl disaster, are the draft regulations on the exploitation of mineral resources in the area, that's the deep seabed area, beyond national jurisdiction. And these are currently being discussed and negotiated under the auspices of the International Seabed Authority in Jamaica. And you can imagine that if we do not have good processes in place, if we do not have funds in place, if we do not have adequate provisions on compensation and liability, that we could have huge problems of marine disasters emanating from deep seabed mining. And I will leave it there with that plug for having responsible law in place in advance of disasters. Thank you.
Thank you, Ms. Neville. I think most of the questions that have been posed on the Q&A have been answered. There's one left for Penelope for you, which says, do IMO treaties restrict mare liberum to mare clausum by limiting the quantum of damages through a process of compulsory insurance? This came up while you were doing your presentation. Is it possible to give an answer to that?
That's a very good question. The extent to which they do that very much depends on it depends on the treaty involved, and it depends which states are party to the treaty and how that's going to sound in the events in question. Not all states are party to all relevant treaties, so not all jurisdictions will be engaged. And so therefore, sometimes, for example, on the Maritime Liability Conventions, which I didn't mention, but under one convention, under the earlier convention, you have a lower limit of liability, but then there's a subsequent protocol which raises that limit of liability. But what you then have is forum shopping, potentially by the parties involved, to try and seize the jurisdiction which is going to be better for them, whether that be the jurisdiction that doesn't have a limitation on liability because it hasn't signed up to one of these conventions, or one that does. And so it's not possible to give one answer. In principle, you could say that yes, it does limit the mare liberum by imposing limits, but on the other hand, there are benefits involved in limitations of liability and managing liability, and also in conjunction with that, setting up funds, established funds contributed by industry in order to make claims against. So you're looking at a balancing of interests for different policy reasons, but how these play out will depend very much on the factual matrix in a given case and how the parties progress their claims.
Okay, thank you very much. Since we are already about 20 minutes over time, I would ask Tanya, but before that, it would be remiss of me if I don't mention Mr. Paul Mainwaganam and Rajiv Amrasuriya for all the effort they contributed in contributing to successfully having this webinar. Thank you both. And I'll hand you over to Tanya to conclude the webinar.
Thank you, sir. I can only reiterate what you have already said. Thank you very much to our panelists, Professor Andrew Suri, Ms. Penelope Neville, Mrs. Mehta, and of course, Chandaka Jayasundara, PC. In the interest of time, I'm going to limit this just to say thank you very much, and the fact that we have this on YouTube available for anyone to follow. Much of our viewers are students also who will very well be inspired by what you have said. Advocates prosecuting companies with limitless budgets in the name of the environment, treaties entered to, and why governments need to be on top of their game to prevent irreparable damage to the environment. That is what we have been discussing. Thank you all and have a good night.